It is my very great pleasure to introduce our three speakers. We have Guzyal Hill, who is an associate professor at Darwin University. She researches and publishes in the areas of national uniform legislation, harmonisation in the Federation, federalism, and law as data methods in the context of legislation. She was previously a legislative drafter. Uh, Paul Burgess is a senior lecturer at Monash University and researches all things the rule of law. And thirdly, we have Rebecca Considine, who is second Parliamentary Counsel in the Commonwealth Office of Parliamentary Counsel, who will be able to offer us a unique perspective from a senior legislative drafter. Guzyal will speak first, followed by Paul and then by Rebecca, and then we will open it up to questions and answers from the audience. So thank you all very much, and over to you, Guzyal.
Thank you very much, Luke. I'm joining from beautiful Larakia country, and I would like to acknowledge elders past, present, and emerging. With today's presentation, so thank you for the slides. With today's presentation, I was invited to speak about my paper, which was titled Legislation for AI, Legislation with AI, round number 1, ChatGPT against Australian Law Council. And it was published in the Loophole, which is a journal of the Commonwealth Association of Legislative Counsel. But before we begin presentation, I would like to introduce myself. So I'm a solicitor. I was admitted to both Supreme Court NT and High Court. As Luke have mentioned, I worked as legislative drafter for Parliamentary Counsel NT. And right now I'm a legal academic, so working with, as an associate professor, researching national uniform legislation, law as data methods, which lends itself perfectly to legislation and AI topics. These are a couple of my articles that have been published previously. But this work began, the work that I'm going to talk to you about began in 2020 when I published a chapter on untapped opportunities for use of AI in national reforms. And before we begin any discussion, it's important to notice that we are lawyers working with AI. And because we are lawyers, of course, our attitudes matter, because it will influence the adoption or non-adoption of AI. And if we think about adoption or non-adoption of AI, we can think about 4 main attitudes. We can think about optimists, pessimists, doubters, and pragmatics. Of course, optimists will say we have to adopt AI with no caution, but that's unusual for lawyers for sure. Pessimists will say that we should not adopt and should not progress with AI, but that's a bit difficult because AI is used quite widely in some non-apocalyptic ways and some are quite strange ways as well, as we know. Doubters, and this chapter was written in 2020, doubters were saying that AI is not developing as quickly and we will not see its development within our lifetime. Alas, they were wrong. We are seeing emergence of AI at a high speed and with some capabilities already surpassing human ability. So, as always, pragmatics are probably most correct, or they are recommending to proceed with caution, rigor, attention to detail, and transparency among both lawyers and legal academics. It's true. Pragmatic approach is important with working with AI because, as we can see, for example, in Canada already, client legal privilege is already in the center of attention when working with AI. Do we keep client legal privilege when we are working with it, or do we not? So this is important consideration. Again, proceeding with caution. Sorry. So I wrote the article in December, the article for the loophole. And then I became instantly famous with some global media picking up this article, and you can see the pictures. I really enjoy the pictures that they have used. It's always robot writing legislation, but of course, in reality, we know this is AI is not at the stage when it will replace humans. We are still talking about augmenting legal reasoning with AI. We are not talking about replacing legal skills. And if we are using it, and we are using it appropriately in pragmatic way, I'm suggesting that major mistakes can be avoided. We can understand automated decision making better, and would have probably not made mistakes that we have seen in Robodebt Royal Commission. If we don't engage with AI as lawyers, legislative drafters, we miss an opportunity to lead international debate and development of law on the emergence of AI. And additionally, which is a little bit more scarier for me, is we will allow experts from other fields to occupy new niches, and they will develop systems that will not take into consideration important areas such as human rights and rule of law principles. So what I have done, taking my judgment into account as a lawyer, as a legislative drafter, past legislative drafter, as legal academic, I looked at capability of ChatGPT. And it proved to be interesting because it has changed over time. And I will show you how it has changed. I decided to work with domestic violence. And I took as an example, you can work on any legislation, really. In the recent article, I worked on disinformation, definition of disinformation and misinformation. But for this article, I took an example of domestic violence because it's a big social issue for Australia, Canada, UK, and other countries. And as a society, we are trying to grapple with an issue and find the balance and enshrine this balanced definition into a law. As you know from the topic of my research, my topic is national uniform legislation. So of course, definition of domestic violence across Australia is not uniform. Each state and jurisdiction and territory has its own definition of domestic violence. That is why Australian Law Council worked with advocacy groups, with people with the lived experience, with government, and developed their model definition of domestic violence. So what we will do, we will compare definition prepared by ChatGPT with the definition prepared by Australian Law Council. And of course, the main takeaway, spoiler, is of course, ChatGPT still is not capable of replicating exactly what lawyers can do, how lawyers can draft. So let's look at it. Let's look at it together. The first one. So this was a definition by ChatGPT 3. I ran it in February 2023 and November 23. So that was just the cusp of change between ChatGPT 3 and ChatGPT 4. But what's interesting about this definition, and this is typical for large language models, ChatGPT classified categories of abuse, of domestic abuse, quite nicely. We already know that large language models are really good in classification and categorization, and that's exactly what they're showing us here. Of course, Rebecca will be presenting later. It's impossible to take this definition and put it into law, but this is a good. This was a good beginning, and that was in February 2023. Let's look at the definition prepared by the Law Council, Australian Law Council. Here, you can see physical and sexual abuse, emotional, psychological abuse, economically abusing. So this is economic abuse is not included in every jurisdiction in Australia at the moment. Threatening, coercive control behavior, and of course the influence of domestic violence on children and other witnesses. So this is really solid definition developed by the Australian Law Council. Please, please, if we can talk about the most recent development. So right now we are in ChatGPT 4, which was launched in March 2023, with the ChatGPT 5 to be launched in they're talking summer, approximately July 2024. So in several months, ChatGPT 5 is going to be released. So here I would like you, this is not in the article, this is already new run. I asked ChatGPT to prepare a definition of domestic violence, but I already used ChatGPT 4 and I already used paid version, not free version. Here, you can see that the definition is already gender neutral, which is great. That's exactly what we are trying to do in our drafting. We can see that there is a classification. We can see it's still substandard. There are some mistakes in, and Rebecca can probably pick up a little bit more mistakes than I can, but we can definitely see mistakes in drafting. But what we can see is if you look at scope of application, it goes wider than just children. It goes into family relationships and, of course, talking about care relationships and more extended family. So yes, that's the most recent ChatGPT 4 paid version, pending release of ChatGPT 5, which we were told will be materially better than ChatGPT 4. But we should not be assuming it will be better for our purposes, because when I ran the experiment in February 2023 compared to November 2023, February previous version was actually better. And of course, we do not have control. We do not have control over ChatGPT output. We, of course, we don't know exactly how the algorithm works, and it might work differently for other people. And everything depends on the prompt as well. But we can see the improvement. We can see the improvement over the years, and we can see the improvement that might be useful for legislative drafters, for people who are working with legislation. It can be law reformers, it can be policy makers, it can be other people. And going back to our butterfly effect, this is a hint to the butterfly effect. Of course, nobody wants to live in dystopian society where AI rules the world, and that's exactly the purpose of organizing an international group, international community of practice, where legislative drafters from around the world are observing development of AI in their countries. So we have participants from Canada, UK, Singapore, and New Zealand, Kenya, and other countries, where we are discussing what's happening right now in each country. For example, UK right now is experimenting with legislative materials that are surrounding legislation, not only the act, but also, for example, ministerial speech, explanatory memorandum, and all other documents surrounding legislation. Jersey right now working with Google AI, and they are developing their customized version of a system. So we are watching. They're probably going to produce the report at the end of this year. Canada is moving quite nicely. They are looking at whole of government approach, and they are looking at use of generative AI by government service through their regulatory institute, through their regulatory institute. Oh, what else? Bangladesh. Bangladesh is quite interesting in the sense of using AI for translating the verdicts from Bengal to English. So there's using AI for translation. So again, thank you, Luke, for this opportunity to present. If you have any questions, please email me, and I'm looking forward to Paul's and Rebecca's presentation. Thank you.
Thank you so much. That was fascinating. I think now we will move on to Dr. Paul Burgess. Over to you, Paul.
Thanks, Luke, and Guzyal, thank you so much for your presentation as well. I'm going to take a slightly different tack. So I'm not opposing tack. I'm going to be sort of sandwiched by two practitioners in many senses because I'm more of a theorist. So as Luke mentioned earlier, I work with Luke at Monash University. Most of my work is in public law. In the last quite a few years, I've been really trying to think about how AI kind of intersects with my pet topic, which is the rule of law. So I've just written, and this is not a plug, I promise, a book on AI and the rule of law. And the reason I say it's not a plug is it's hideously expensive. So by all means, don't go dashing out and buy it. If someone is so desperate they want to buy it and they want a 20% discount code, drop me an email and I will send that over. But I have to say, as an ex-publisher, I was a little bit disappointed to see how expensive it was. So apologies to everyone on that. But in that book, I do raise a question. I think it's a really important and valid question, and that is, how will the rule of law need to change in order to account for a future in which AI is used to exercise power? And today I want to talk about really just a small part of that. And that's one of the chapters where I talk about how AI might be used in exercising legislative power. And as I do that, I want I suppose the four categories raised before, I'm going to be a bit of a pragmatist. I'm going to really think about the fact that we need to be cautious, but I will point to three of Guzyal's other categories where I'm also going to say, well, there are some problems and there are some potential protections, but I may be a bit negative and focus on problems, and you'll see why. And to do that, I want to focus on what I'm going to call a very hypothetical. And it will become pretty apparent that this is hypothetical, but it is really not going to be a hypothetical that I think will happen tomorrow or next year or even in the next 10 years. It's technologically not possible, it's sociologically unlikely, and it's legally a complete unknown. But in saying all of that, I think extreme hypotheticals are actually really useful to illustrate both potential benefits and potential problems in the extreme sense. And I also think they're quite good fun as well. So the hypothetical is, we are going to get rid of the legislature. At least we're going to get rid of the legislature as it is currently populated by human legislators. And we're going to replace those human legislators with algorithms who are elected in the same way as our existing legislators. So we're holding basically everything else constant, and we're replacing those humans with algorithms. And those algorithms will be responsible for proposing, debating, and passing primary laws, legislation. Now, very conscious Rebecca will be speaking straight after me. This does simplify the impact and the importance of legislative drafters, but I'm sure Rebecca can point to that contribution in a moment. Now, as I said, this is a very extreme hypothetical. And what I want to do is point to the sorts of rule of law related problems that might arise in this sort of situation. Now, for those of you who maybe know something about the rule of law, or at least go into the rule of law in depth, the first thing you're probably going to say is, well, Paul, it's a contested concept. How can we say exactly what it is? And that's quite right. So I'm going to skim over that and we'll simplify at some level. But it is important to remember, of course, that I'm speaking from Australia. this country professes to be a rule of law country. It is a country that, in line with the idea of the rule of law, opposes the arbitrary application of power. Now, if we're going to think about what some of those rule of law ideas are, for example, they might come from some popularly invoked thinkers. Aristotle, Locke, Dicey, Hayek, Fuller, Raz would be some of those that come up frequently. There are some more recent ones, people like Tom Bingham, who have a much thicker idea. Our own UNSW, Martin Krieger, Julian Sempeler, Melbourne Uni, all coming up with great rule of law ideas. But those first, more historical group of figures are the ones that really come out or are most frequently pointed to. So I'm going to focus on those, and maybe we can get into Q&A about some of the newer ideas later. And in thinking about them, I want to think about some of the problems that might arise in that hypothetical I mentioned. And the problems are easy to see. See spelled S-E-A. That's intentional, of course. Speed, explainability, and accountability are the three key things I'm going to point to. So we'll talk about speed first. Now, for those rule of law people out there, you would say everybody knows Aristotle says it's about the rule of law, not the rule of man or the rule of people. Aristotle's point at some level seems to be that there needs to be some sort of legislative due process. Laws should be made carefully and slowly. There's a problem if we're going to make laws in a knee-jerk or in an emotional way. So that's a classic rule of law idea. Well, what about if AI exercises power? What if laws are made very quickly? What if they're made in 1,000th of a second? They're proposed, debated, and passed within 1,000th of a second. Well, if you're like me, that seems to feel like it's a problem, but it seems, well, in my view, it is a different problem to what Aristotle saw. For Aristotle, it seems to be an internal problem of speed. The fact that if we're trying to do things quickly as humans, we're more likely to make mistakes. We're going to have problems in that sense. But that doesn't seem to be what happens if AI is doing it necessarily. Just because AI makes decisions quickly, far quicker than a human, doesn't necessarily increase the chance of error, doesn't include the sense of emotion. So what we might see there is, well, there is a speed problem, but it's an external speed problem. Decisions might be being made so quickly that they couldn't be engaged with, even if we suddenly got 10,000 pages of Hansard to document that very extensive debate that did take place. So what we see there is, well, our problem that does exist in the rule of law, one of speed, but it's a different manifestation of that problem. So that's speed. Let's think about explainability. Now, this could be seen as a very common rule of law idea. This is the idea that the making of laws needs to be predictable and transparent at some level. We need to be able to see how the sausages are made. The idea at some level is that this seems to mean if we can see how the laws are being made, that makes lawmaking non-arbitrary. We can see and understand both where power comes from and how it's being exercised. So these seem to be good things. But as I'm sure you know, complex algorithms are effectively a black box. We can't really see how the algorithm gets to the answers it gets to. We can maybe infer that. We can see what goes in, the data that goes in one end, and we can see what comes out the other end, and we know what it's been told to do, but we don't actually know. Now, explainable AI is a problem that is being dealt with on the IT side of things extensively, but I want to address that in a slightly different sense, because this sort of black box idea does seem to reflect a real rule of law problem. It seems to lead to a fundamental idea of non-explainability. But maybe this is the optimistic view. What are we comparing that with? If it's to human legislators, do we know how human legislators make decisions? Now, of course, they can tell us, and they can debate how and why and when they make decisions. And at some level, so can an AI. And I don't mean this to sound scathing. Do we know if they're giving an accurate account? I don't want to say not telling the truth. They may be completely telling the truth as far as they're aware, but do we as humans fundamentally know how we make decisions? As you may appreciate, I'm not a neuroscientist. I don't know how that works. My only point is to try and bring back this idea of a comparator. is it actually the case that we fundamentally know and understand how we as humans and our human legislators make decisions? If we don't, does it really matter that an AI is a black box? So maybe there is a problem, but maybe that's not a new problem. Third category, final category I'll touch on is accountability. Now, this isn't a specific category noted by the the rule of law, what I call usual suspects, Aristotle, Locke, Dicey, Hayek, Fuller-Raz, those sorts of people. But accountability does underlie those ideas. It is the suggestion that the prevention of arbitrary power is really achievable through being at some level accountable. And we do that with lawmakers through things like criticism, through voting them out. But think for a moment whether that would work with an AI legislator. It seems like an AI, on its face, may not care about being re-elected. It might not care about being criticized. It might not care about maintaining power. Unless we program them with a desire to keep voters happy and to do whatever is needed to retain power. But I'm sure I'm not the only one in thinking that in and of itself may lead to some problems. It's also maybe the case that an AI in and of itself may not care about personal and professional sanctions. At the most extreme level, we can't send an AI to jail. It may not even care about, as I said, being voted out. So the impacts that may happen, the idea of accountability may not affect an AI in the same way as a human. So here, thinking about the problem, well, an AI is not motivated to avoid arbitrary power making in the same way, and unless we make them that way, but as I said, that in and of itself seems more problematic. So I'm conscious of the time, we're pretty much good. In considering this sort of very extreme hypothetical that I've sketched, albeit, as I said, consciously it being extreme. An extreme hypothetical where I'm suggesting, well, what happens if we have an AI creating primary legislation? There do seem to be a number of rule of law problems. And some of these problems are familiar, but different. So think about the speed example. We do have a speed problem, but it's a different form of problem. Some of the problems may on their face seem to be different, but they're actually kind of the same. Explainability, the idea of being able to look within that black box and bringing in the idea that maybe we're a bit of a black box as well. And finally, thinking about the fact that some of the problems may be genuinely new. Even though accountability is an age-old problem, the problem here is we fundamentally cannot hold an AI accountable in the same way that we can hold a human accountable. So the effect of this in relation to the book conclusion is that, well, if that's the case, we actually need to evolve our idea of what the rule of law is in order to continue to protect against the arbitrary application of power. But the more practical effect, and quite useful for this forum, which is the forthcoming book project, is that if we are in a society that is a rule of law society, there do seem to be some sort of limits that exist as to the kind of powers that can be exercised by an AI in a sort of legislative sphere. Now, these limits can come from positive regulations. We can create rules that say what we can and can't do when we are using AI to exercise power, and that's great. But it does also seem that the rule of law and other big picture public law concepts themselves might be able to give us some red line limits as to what needs to be or what cannot happen in relation to the exercise of power with, and for an AI. So yeah, the rule of law is not only useful to exercise or prevent the exercise of arbitrary power, but I do think we can use it to set limits in the future as to what an AI can or maybe should be used for in the exercise of power. Thanks.
Thank you very much, Paul. That was fascinating theoretical perspective on the issue. Our third and final speaker is Second Parliamentary Counsel, Rebecca Considine. Rebecca, over to you.
Thanks very much, Luke, and thanks to Guzyal and Paul. I just want to say up front that I've done a lot less thinking about this than Guzyal and Paul, and I'm also going to drop a spoiler that OPC does not at present use AI in legislative drafting, in case anyone was wanting a big reveal there. However, the potential that it has to contribute to the work we do is definitely something we're starting to think about. I think maybe perhaps before I offer some reflections on that, I should perhaps take a couple of minutes to just briefly tell you what OPC is and what we do. Some of you may well be aware, but I began my legal career in Melbourne as an article clerk, and in the 5 years I worked in Melbourne, it never once crossed my mind that there might be human beings in Canberra generating the laws that Parliament enacts. I was certainly aware that bills came through Parliament, but as to the origins of those bills, I never turned my mind to it. So the Office of Parliamentary Counsel is an independent statutory office located in Canberra within the Attorney General's portfolio. We're part of the public service, so we're part of the executive branch, despite the Parliamentary Counsel title. We're not part of the legislature. We have two functions. We draft laws and we publish laws. I'm not going to say very much about the publication side of things, but just for completeness, we build and maintain the Federal Register of Legislation, and our publication staff prepare compilations of federal laws. On the drafting side, the drafters draft all of the government bills and parliamentary amendments that might be made to bills while they're going through Parliament. We also draft a fair chunk of the subordinate legislation, and we provide some drafting assistance to private members of Parliament as well. So I've already told you that we don't currently use AI. We have a few automated processes, but I wouldn't say that they're intelligent in any sense. So what do we think AI might be able to do in the legislative drafting space? Some of you might have seen online a piece by Richard Susskind, who's the UK president of the Society for Computers and Laws. He has a piece up at the moment called "I Asked ChatGPT to Write Some Laws, and This Is What It Did." And he actually thought it wasn't too bad, in fact, pretty good. He was impressed, and he reckons in about 5 years, AI could be writing complex laws for us, leaving aside all of those questions that Paul's raised about whether that is actually consistent with the rule of law. Look, when ChatGPT first came out, which I think was around 18 months ago, we did have a look and a bit of an experiment. Obviously, perhaps like a lot of the work a lot of you do, everything we do is in confidence. We can't simply suggest some drafting instructions that we've received to ChatGPT, but we did have a bit of a go. And as a group of drafters, I think I would say we were in equal parts amazed and alarmed and entertained by what it came up with. You know, it was sort of superficially plausible, some of it. But, you know, it can do simple things, but it couldn't, and I think this is consistent with what Guzyal is saying as well. It overall doesn't, it's not there yet. But, you know, I wouldn't rule out that it's going to, if we were able to use a proprietary model and train it specifically on our laws and our processes and our practices, I really would be interested to see what it can come up with. At present, there's nothing like the precision and detail that we need. And also some key things that it can't do at present, at least. So it doesn't understand, I think that perhaps of interest to all of you, that there's a constitution which is the source of the Commonwealth's lawmaking powers. So, of course, all of our laws need to draw from a constitutional legislative base, and they also need to operate within the constitutional limitations, which is not necessarily as simple as putting a fence around something. You know, in some cases, I'm thinking of things like the implied freedom of political communication. You know, that limitation needs to permeate the design of the law, and, you know, you're adding and subtracting and shaping things to fit within that. And, you know, I just don't see that it can do that at the moment. And I guess I would need an expert in AI to advise as to whether they think that an AI could ever get to that level of the sort of evaluative and judgment-based work that lawyers do, and specifically what legislative drafters do. I'm going to throw in too that I think its language is kind of stilted and weird, and I think the humans are currently way ahead in terms of style. Perhaps I should step back for a moment and just say, what do legislative drafters do? As I said, when I was working as a lawyer myself, if I had been asked how did I think these things created, I might well have imagined that a machine did some of it. Actually, a machine does almost none of it. It is an extraordinarily hands-on, manual human process. We receive drafting instructions from departments. They are generally written documents. We analyse them, we meet with people, we discuss them, we might do a little bit of research ourselves. We tend to rely largely on the information we have from instructors, although of course we test that, we ask a lot of questions, and ultimately we take that into what we believe to be a legally effective, workable and constitutional framework for the law. What this actually means in practice is highly variable. You know, there are some really sort of basic things that we do that, you know, change the XYZ corporation to the name ABC Corporation. I would love a machine to do that for me. You might be surprised to know that there isn't a machine to do that for me. Someone has to produce that text. In other respects, you know, where there are very, you know, enormous and complicated laws that take a lot of, you know, in some cases, years of analysis, judgment, balancing, as I said before, taking things out, putting them back in. You know, at the moment, you know, there isn't an AI that can do that. We would need an in-house version of one, and that raises questions as well about sort of the vendors we can use and, you know, the technology they are providing us with. You know, and I think it's probably worth acknowledging, though, as Paul did, that humans aren't perfect either. So what can an AI do that might actually help us? And I think that's perhaps a more useful question, and probably more what Guzyal was talking about, is how can it help us do our job? I don't think it's going to put me out of a job. I don't think it's going to put any of the 25-year-olds currently working here out of a job either. But it might actually really improve the way we do things. So, you know, it can do little things. It can produce minutes of meetings and so on. I don't know how many of you have tried that. It's not awesome, but it's, you know, it's okay, and it's a tedious job, and as long as it only has to be adequate. It can produce summaries and perhaps find judicial consideration, analyse the interactions of laws. I would love to test it with coming up with, say, a good precedent that combines kind of, you know, being able to compare the features of a particular thing, perhaps the sort of thing that Guzyal has done with the definition of domestic violence. Having said that, I gave it a go with the definition of Commonwealth agency. So what are the common elements? And it came up with some good stuff. And then I said, what is the most commonly used definition? And perhaps those of you who understand this technology better will tell me why I didn't get a very good answer. But it came up very confidently with, you know, the Acts Interpretation Act 1901 has this excellent, this definition, which has, you know, and I thought, wow. And I went and checked, and it's definitely not there. There is no such thing in there. But it was good that it knew the Acts Interpretation Act was the place to go, but it just asserted it with such confidence. And that's why I say I think the superficial plausibility of it does concern me to a significant degree. I would love to be able to use AI to analyse, compare and contrast provisions that are drafted differently, but potentially trying to solve the same problems. And I've been reading recently Daniel Kahneman's book on noise, which you might not know as the kind of variability of human decision making. So where experts make different decisions that are widely variable for reasons not explicable by bias, I think maybe AI could help us understand where those things are happening and maybe improve consistency. So, I think perhaps my grand conclusion, and similar to what Guzyal was saying, it's not going to replace us yet, could definitely do useful things for us. Paul mentioned the AI legislature. Another question is whether AI could be used to turn laws into machine readable code. Drafters for quite some time have been talking about law as code. Wouldn't replace law as text that humans can read, but help us create interfaces for very complex laws that can answer people's questions and perhaps make outcomes clear without necessarily wading through 100 pages of something. Look, I guess, I'd say we have to be obviously aware, and both our other speakers have pointed to this, they're very significant issues. I spent 5 minutes and, it made up something for me. And also, I think those questions of the potential bias, these things are originally made by humans, of course. They do contain values, and we need to know what those are. Most particularly if we're using them to assist in the creation of laws. And as I say, I don't think they're creatively all that impressive, just in terms of the style of the text they produce. It just sort of has a particular kind of identifiable tone at present. But I could absolutely see that changing as it gets better and as we train it on something specific. That's kind of all I've got to offer, and I want to make sure we've got time for questions. So, Luke, I'll hand back to you now.
Thank you very much, Rebecca. Fascinating reflections on the possible uses of generative AI in legislative drafting from a practitioner perspective. We'll now open things up to question and answers from the audience. So feel free to type in any questions you might have to particular panelists or to panelists generally in the chat function. But I might use my moderator's privilege to ask the first question. And I suppose it's to all three of the panelists from their varying perspectives. What do you think is likely to be the first use of generative AI in the legislative drafting process or ancillary functions somewhere within Australia? And I might put that to Guzyal first.
Australia is taking a cautious position, like Rebecca already said, and that's probably is okay. Canada, interestingly, Canada is because they already have their bi-jural jurisdiction. They're using French and English to write legislation, so they are already using AI to code, like exactly what Rebecca said, to code legislation into rules as code. That's what's happening right now in Canada, and UK is using it for explanatory materials. But Australia took cautious position, and Rebecca confirmed, and as far as I know from NT and Western Australian Parliamentary Counsel, that's what's happening at the moment. Thank you, Luke.
Rebecca?
Yeah, look, I think we're still a little way away from, I think essentially we need a confidential, like a proprietary in-house version to use. I could certainly see it being used to compare and contrast precedents, to identify gaps in particular provisions. I think we would be looking at using it to create consistency or to look for opportunities for consistency.
And Paul?
Yeah, obviously I'm coming at this from a very non-practitioner perspective, but to Rebecca's point, that was certainly the thing I was thinking, is leaning on the strengths of what generative AI and large language models generally are able to do, which is synthesize a large amount of of data and actually try and find where there is commonality or where there is a gap. You know, being able to say across these 5 very extensive and lengthy pieces of legislation, what is a definition that would be common across whatever, or one that would not contradict all of these things. And again, being very conscious of everything that's been said so far, which is having that human in the loop. Obviously, it's not asking the generative AI to have a look at this thing and then it becomes a regulation. It's then being able to say to the people with this expertise, the drafting office, does that sound right? And all of a sudden, then you can go through the normal process, but at least have a little bit of a head start.
Thank you all. We have a first question typed in from Roger Jacobs, Deputy Parliamentary Counsel of Western Australia. And he writes, Rebecca, evaluative judgment of drafters. Thank you. That function that drafters perform in evaluative judgment is essential to the development of functional laws and the protection of society, including from misconceived ideas in the working out of high-level policy. So I suppose that's a prompt to reflect on the balance between algorithmic power versus evaluative judgment in actually applying working out the drafting of laws. And I suppose, what's the balance between technical nous and evaluative judgment as it relates to generative AI and legislative drafting? Maybe this, Rebecca.
Thanks, Roger. Look, I think at the moment, I would say we haven't really sort of tried to pull apart or kind of work out what proportion of time we spend making evaluative judgments versus technical. And I'm not sure if this, Luke, maybe step in if I'm misconceiving the question. I don't, as I said, I am I'm a doubter, I think, in Guzyal's framework in terms of AI's ability to make evaluative judgments. But I also take Paul's point that humans are not necessarily brilliant at that either. And what I would like, knowing, not much as I don't about AI, being able to kind of use the tool to assess kind of where a range of judgments, different judgments have potentially been made in equivalent situations or to produce different outcomes, and just actually look at what is the variability there, and then as humans to ask ourselves how warranted that sort of thing is. So I could see it as being an aid to analysis, because we know AI is great at finding patterns and finding anomalies in patterns. But as far as I know, we don't think that it would be necessarily good at assembling all the parts and appropriately weighting them to bring them within, say, the implied, so that they're not burdening the implied freedom of political communication or something like that. I think we still need humans there. We might be able to use AI to say, well, here are 7 examples of laws that have not yet been struck down or that the High Court has found okay. But I think we still need the humans to draw those conclusions, I think.
Thank you for that very thoughtful response. Guzyal and Paul, did you have any thoughts on evaluative judgment, drafting, and the function that AI may be able to perform in relation to that?
I don't have point regarding evaluative judgment, but I do have point regarding comparative abilities of AI, as Rebecca mentioned. Just when I was talking to LexisNexis, they also, of course, have AI division. Thomson Reuters and LexisNexis have AI division. And what LexisNexis have launched is called similar provisions. So in some areas, so for example, construction law. In construction law, for national uniform legislation, there security of payment legislation has similar provisions. And if there is a balloon and you can click on it, and it will show you similar provisions in other jurisdictions. This is the function they launched in 2021, as far as I remember. And they were going to improve this function and roll it out across all other areas of legislation. But that's not evaluative judgment. So I will pass on to Paul. Thank you, Luke.
Well, that's a really nice point, because as Rebecca was giving her answer, one of the things I jotted down that I think relates to evaluative positions, but it also speaks to your point, Guzyal, is it prompts us to be better in some sense, or it actually requires us to be better. And I appreciate, given it is a Monday lunchtime, I am speaking to the converters here. But if we start to get a response from AI that says, okay, there is a good thing here or there's a bad thing here, we have to be very consciously critically engaging with that and being able to not be subject to confirmation bias one way or the other. We might say, well, that's obviously completely rubbish because it's AI, or we might say it's completely right because it's AI. We actually have to then engage more consciously with that, even than I think we have done in the past. And to the Lexis tool that you mentioned, one of the things I find really interesting with that is the potential for it to identify a similar provision that may not have been on a lawyer's radar previously, which causes them to maybe raise that in argument, which causes a judge to evaluate, which causes a judge to go off potentially, and quite rightly, in a different direction, or almost nudging, in effect, the direction that laws may end up going. And I don't speak to that as a good or a bad thing. It's just a different thing, that direction may end up happening purely and simply because the AI that underlies the similar provisions function has said, hey, have you seen this before? And so really interesting stuff. But on that evaluative side, we absolutely, I think, have to be even more cognizant of what we are doing, because otherwise the AI will just be going in whatever direction it wants.
Thank you. I am conscious of the time, so I might just give each of our panelists an opportunity to offer some final thoughts or reflections before closing the webinar. So might start with Guzyal, then Paul, then Rebecca, so the order in which we spoke.
First of all, thank you for organizing this webinar. That was amazing. Oh, I was amazed to hear from Paul and Rebecca. Thank you. I think I will finish up with the word of caution. Most of us here in this room are lawyers, and if lawyers don't engage with AI, basically we will allow experts from other fields to occupy this niche and lead national debate, and they will not know everything that we know. And this is important for us to be engaged, to be cautious, like Paul said, but also not to ignore the developments. Thank you.
Thank you very much.
If I can echo the thanks as well, Luke, thank you for bringing this together, and thank you for the other speakers and for everyone for coming. I'm going to do a cautionary note, and that is very simple. Be very aware when AI is coming into our day-to-day tasks. I'm assuming my publisher is not on this call. When you write in emails, when you write in Google Docs, and there's the auto line complete, it may well be that you end up writing a research-based textbook that is 20% written by AI. And I don't know what that means legally, practically, or for anything else. There's obviously been a human in the loop. But AI comes into almost everything that we do now, whether we know it or not. So as long as we're vaguely aware of that, I think that's a great thing.
Thank you.
Thanks, Paul and Guzyal, and thanks, Luke. I can only echo the wrap-up comments of both Guzyal and Paul, and just add that, in my view, I think not only the drafting of laws, but the development of policy and the enactment of those laws needs human control, ultimately. And that the AI might be extremely helpful, but we need to take real care.
Thank you very much, Rebecca. And thank you once again to our three speakers, Guzyal Hill, Paul Burgess, and Rebecca Considine. That concludes this lunchtime webinar. You can keep an eye on upcoming in-person seminars and online webinars from the Australian Association of Constitutional Law on the website, which is www.aacl.asn.au. Thank you, everybody, for coming, and I hope you enjoy the rest of your day.